coming to your LLP Act 2008. I know the chapter which you keep for the end. Some of you even put it in option because you feel कि question number 2B एक ही question आने वाला है 5 marks, so we can easily leave this chapter in option. But bacha, this is the biggest blunder you are making. I agree. I will not deny that the weightage is 5 marks. So according to your calculation, you will leave it in option. Because by the time you are done with the other 4 chapters, you are so tired. You are like, yaar, LLP yaar chodo. Yes. But what happens is, bacha, when you leave this chapter in option, you have to by default leave question number 2 in option. It is very well possible that question number 2A might be a very good question of 7 marks and which you know properly. तो तुमको तो by default वो छोड़ना पड़ेगा. चलो वो भी नहीं यार. So you have left LLP in option. So you have left question 2 in option. This is possible only if you know all other questions properly. Every paper will have one or the other question which is a little tricky. Especially the SOGA questions, which are practical based questions. They are so tricky that you feel this also can be answered, this also can be answered. So such questions, bacha, you have to leave an option and not the entire chapter. And eventually when you do articleship, some of you might go to Big Fours and all. Big Four is an LLP, EY is an LLP, Deloitte is an LLP. And most of the CA firms nowadays are LLPs. Of course, there are normal partnership firms also, but most of them are LLPs. So yaar, eventually it is gonna be used somewhere in your career. So why are you leaving it? And it's 2008, means it's a recent act. It's not like your Contract Act or SOGA, which is like 100 years old or something. So you are gonna use this a lot in practical life. Trust me, after this video, you will be very comfortable with this chapter. In this video, what I'm gonna do is, I'm gonna give you a gist of the entire LLP Act. If you are aware, 2-3 years back, some things were added by the institute. I'm going to add that here. And recently in your RTP, they have put 16 pages amendment. So again, when you see those amendments, you are like, kuch samajh mein nahi aa raha hai, so we will leave it in option. So in this video, I am going to give you the entire, you can say, short explanation of LLP Act, including the additions which happened 3 years back, including the amendments which happened recently. So in short, once you do this, you are sorted. 5 marks, and boss, don't underestimate the power of 1 mark. 39 is a scary score. So please, I request you from the bottom of my heart, do not leave this chapter in option. Okay. So this is me, Professor Manasi Patil from JK Shah classes, starting up with your LLP Act 2008. Now, in spite of the Act being introduced in 2008, but the actual introduction date is 31st March 2009. So, a lot of students ask me, so ma'am, are we supposed to write 2008 or 2009? But 2008 mein Parliament finalized it, and actual 2009 onwards it was introduced to the public. So, when you are writing LLP Act 2000, you have to write 2008. But if they by chance ask you introduction date, then 31st March 2009. This act has 81 sections and it has 4 schedules. And these schedules are also very nice. What are these schedules about? See, just as in your Partnership Act, you had partnership deed, which is optional. If you have partnership deed, okay. If you don't have it, you can just follow the rules of the act. Same case, even LLP Act is very chilled out. So, LLP Act says, if you have LLP agreement, okay. But if you don't have LLP agreement, you have to follow the rules given in Schedule 1. So, Schedule 1 is regarding LLP agreement. But if you choose to have LLP agreement, it should be in writing only and it should be registered with ROC. Schedule 2, initially you opened a normal partnership firm and now you want to get converted to LLP, you can follow Schedule 2. Schedule 3, initially you had opened a private company and now you want to get converted to LLP, you follow that. And lastly, Schedule 4, you had initially opened unlisted public company and now you want to get converted to LLP, you follow Schedule 4. See, use common sense. How can you convert Reliance or Infosys into LLP? It's a listed company. So, only unlisted public companies are allowed to be converted to LLPs. Okay. So, what exactly is LLP? If I tell you a small point, let's talk about a normal partnership firm. The normal partnership firm, the bad things about a normal partnership firm: unlimited liability, there is no separate legal existence, there is mutual agency, One partner does something, everyone becomes responsible. So these are the three disadvantages of opening a normal partnership firm. But the good things about a partnership firm are, it is very simple yaar compared to companies. And the laws are also very simple. Laws are also simple. Compared to your Companies Act, laws are also very simple. If I talk about a normal joint stock company, the bad things, it's very complex, very complicated. Even the laws are also very complicated. But the good things are, boss, it has limited liability. Yes, it has separate legal existence, and it has no mutual agency. So if one shareholder does something, other shareholders are not responsible, the company is. So what government has done? Government has brought good things about partnership, and they have brought good things about company, and they have made LLP. So I can say LLP is a mixture of both. I told you in a very recent way in your module, they have given LLP is a child of partnership and company. So it's a hybrid of both. So in LLP, partners' liability is unlimited. Yes, partners' liability will be limited to the extent of agreed contribution. So if I become a partner of LLP, I'll be like, first my liability is limited to 5 lakhs. So tomorrow, if you need money, I'm going to pay you only 5 lakhs. If that is not enough, that's your problem. Secondly, bacha, separate legal existence. Mansi is different and LLP is different. And there is no mutual agency. See, just as in companies, the name ends with limited or private limited, in LLP the name ends with LLP. So let's say A, B, C and D are partners of LLP. But in the eyes of law, LLP is different and A, B, C, D are different. They are not agents of each other, bacha. They are just agents of LLP. Ma'am, nahi samjha. If A does something, B, C, D are not liable, LLP is liable. If B does something, LLP is liable. If C does something, LLP is liable, and D does something, LLP is liable. So ये लोग एक दूसरे को liable नहीं करते, ये लोग LLP को liable करते हैं. So they are not mutual agents, they are just agents of LLP. Okay. And compared to Companies Act, it is very simple. You don't have directors and all of that. Directors and shareholders are different. Here you don't have anything like that. Laws are also very simple if I compare it with companies. So all in all, it's a good mixture of both. Just as OPC is a mixture of sole proprietary and a company, similarly this is a mixture of partnership firm and a company. Okay, so this was my introduction, basic as to what is LLP. Now, they have given you certain characteristics and all. See, first of all, 31st March 2009, 81 section, 4 schedules. And bacha, just as in companies you had MCA, Ministry of Corporate Affairs, and ROC. In partnership firm you had ROF, a registrar of firms. Here you don't have registrar of LLP as a alag se, only MCA and ROC. So ROC and MCA both are going to take care of companies as well as LLP. What is the need? LLP meaning and concept, just as you know company means a company, same way LLP means a LLP, incorporated and registered under this act. Characteristics of LLP, majorly I have discussed all. Artificial person, yes, again separate legal existence, no mutual agency, all partners are agents of LLP alone. No one partner can bind the other partner by his acts. Then common seal, just as in companies it's optional, here also it is optional. Limited liability. Now, a very important part, bacha. How many partners are required? I'll tell you about that. But here there are two types of partner. One, you have designated partner and you have normal partner. Bacha, you don't have this bifurcation in your normal partnership. You have this only and only in case of your LLP. So what does designated partner do? He is into management and he also ensures legal compliances. Matlab, it is designated partner's responsibility to ensure that all the laws have been followed by LLP. It is designated partner's responsibility to sign in all the documents of LLP. So, but normal partner is just gonna do management. So, who is more important? Designated partners. So, designated partner is very important. You may or may not have normal partner, but it is compulsory for you to have a designated partner. So, the question is minimum how many partners? Minimum 2 designated partners are required, out of which one at least should be resident in India for 120 days. Earlier it was 182 days, now it is 120 days. See, common sense use करो. 2 designated partner है. If both are out of India, who will check legal compliance? Who will sign? At least one should be in India, no, for 120 days. So minimum 2 designated partners, and maximum there is no limit. Now the next question is, ma'am, who can be a designated partner? But it is not some degree or something. I mean, there is no rule that only a chartered accountant or a company secretary can become a designated partner. Any person can become a designated partner, but he has to first obtain DIPIN. Just as you have director's identification number, here this guy needs to have designated partner identification number. Anyone is okay, but you need to have DIPIN. Are you clear up till now? Perfect. So you may or may not have normal partners. Now bacha, how can you become a partner? How can you become a partner in your LLP? So there are 2 ways. First, you can subscribe incorporation document. Just as in companies we had memorandum of association, and in that I had told you subscribers of memorandum are the first shareholders. But we cannot use the term shareholder because company has not yet come into existence. Similarly, instead of memorandum, here you have incorporation document. ये memorandum जैसा ही होता है, where it will be subscribed by first partners of the LLP. First partners. So how you can become a partner? तुम subscribe कर लो, नाम लिख दो, signature कर दो. Yes, and automatically once LLP is registered, you will become the partner of LLP. So you can subscribe incorporation document, or you can become a partner by following rules of LLP agreement if you have any. So LLP agreement में बच्चा rules लिखा होगा कि how can you admit a partner, how can you expel a partner, how can a partner retire. तो वो follow करके आप partner बन जाओ. But ये तब होगा when you have LLP agreement. If you don't have LLP agreement, तो law follow करके admit हो जाओ. But बच्चा, whoever is a new partner coming, you need to obtain a prior written consent. कि boss, he is okay to become a partner in this LLP. And this prior written consent also should be submitted to ROC. This तो you know yaar. In companies also ROC wants to know everything. Even in LLP ROC wants to know everything. So how will you become a partner? You subscribe incorporation document, or you follow LLP agreement, the rules given therein. But prior written consent is definitely required. Clear up till now? Perfect. Next question. Who can be a partner? Either he can be an individual or he can be a body corporate. Individual means person like us, natural person. कोई भी चलेगा, but he should not be minor. He should not be of unsound mind. He should not be declared as insolvent, or he should not be undischarged insolvent. Now what do you mean by undischarged insolvent? ध्यान से सुनना. An insolvent who has not been yet declared as solvent. वापस. An insolvent which is not yet declared as solvent. मतलब यार तू अभी भी insolvent है तो तू नहीं बन सकता partner. जा. Or you should not have applied for insolvency. You know, there is one law in our country, Insolvency and Bankruptcy Code. So if some person has made an application under that act to be declared as insolvent, he is also disqualified to become a partner of LLP. So applied for insolvency, not allowed. So I'll repeat, any individual can be a partner, but of course he should have DIPIN. He should not be a minor, unsound mind, undischarged insolvent and applied for insolvency. Now body corporate, this term keeps coming. Now there is a complicated definition given in your module at least. I am gonna simplify it for you. So who is a body corporate? 4 persons. Indian company, foreign company, Indian LLP, foreign LLP. You know the definition of foreign company, same is the definition of foreign LLP. Foreign LLP is an LLP which is incorporated outside India but it is having a place of business in India. Simple, same thing. So bacha, when I said these 4 are body corporates, that means these 4 can become partners of LLP. मतलब एक इंडियन फॉरेन कंपनी दूसरे एलएलपी की पार्टनर बन सकती है, एक इंडियन फॉरेन एलएलपी दूसरे एलएलपी का पार्टनर बन सकता है. So they all come in the category of body corporate, but it excludes someone. First one is corporation soul. Now the word soul means one person. I can say corporation soul is a position where person is not important, his position is important. For example, when Queen Elizabeth passed away, the UK did not stop. The next person became the successor, correct? If he passes away, next person will come. So the person is not important, his chair or his position is important. That is a corporation soul. Another example, father of a church. If he passes away, the next senior most father will come, Pope, right? Then president, if he passes away, the next person is going to come as president. So that person is not important, the position is. But he cannot be a partner in LLP because it excludes them. It excludes them. Are you clear? Second, any other body corporate notified by government. So bacha, you might be a body corporate. You might be an Indian foreign company or LLP, but government ने specifically आपको notify करके रखा है कि तू partner नहीं बन सकता, तू body corporate में नहीं आएगा, तो तू नहीं आएगा. Third one, cooperative societies. So these 3 are excluded, they are not allowed to become partners of LLP. So 4 points, Indian foreign company, Indian foreign LLP, but it excludes corporation soul, body corporates notified by government and cooperative society. But I have a question for you. अगर ये चारों में से कोई भी पार्टनर बनता है, बच्चा ये लोग तो सब आर्टिफिशियल पर्सन है, तो साइन कौन करेगा? तो ये लोग ना अपने यहाँ के 2 लोग एज अ रिप्रेजेंटेटिव भेजेंगे कि भाई हमारी तरफ से these 2 people will be considered as partner. You will not count them as 2 partners, you will count them as 1 partner only. Clear? So yes, management, all partners can do management, but only designated partners are responsible for legal compliances. Minimum, maximum, I told you. You cannot have a non-profit LLP, it has to be set up for business only. So this definition, they have just rectified it in the amendment. Business will include every trade, profession, service, except any activity which central government will exclude. Matlab if something is declared as illegal, you can't do that. All this is fine. Clear? Now small LLP is very, very important because this is the recent amendment. Just as you had a concept of small company, it's a company where paid up share capital, it's a company which is other than public company, that is private company, whose paid up share capital does not exceed 2 crores and its turnover does not exceed 20 crores, right? So यहाँ पे small LLP is an LLP whose contribution of the partners do not exceed 25 lakhs and the turnover does not exceed 40 lakhs. Simple. ये mock test paper 1 में भी आया था. You know, sometimes they can, if you are lucky, they can just ask you explain small LLP 5 marks. 3 point लिखने से 5 मार्क मिल रहा है. कभी कभी सोगा का इतना भर भर के लिखते हो contract act, if you write, still you may not end up getting marks, but here you will get. That's why I'm telling you, do not leave this. So whose contribution does not exceed 25 lakhs and the turnover does not exceed 40 lakhs or any other requirements which is given. And see bacha, this part is also similar to your company. Or such higher amount which may be prescribed, which should not be more than 5 crores or 50 crores. So when you are expected to write the definition, you have to write the entire thing. 25 lakhs, 40 lakhs. हमेशा याद रखो टर्नओवर का फिगर ज्यादा होता है. वहां पे भी 2 and 20 था, यहाँ पे भी 25 and 40 है. We finish this. Types of partners. How will you become? Incorporation document, agreement के हिसाब से, prior consent required, and you have to submit it with ROC. And DIPIN is required. So this part they have just added in the amendment. So it was there somewhere earlier also, but now they have clarified it properly, like very clearly given. Who can be a partner? Individual, body corporate. And at least 2 individuals will be treated as designated partner. Now, number of partners, to which we discussed, there are 2. But what if one partner dies? LLP is not going to dissolve because there is perpetual succession. So, out of 2, if one dies, let's say Mansi and Mr. X, we both are partners of LLP. Mansi मर गई, तो आज मैं मर गई, तो कल थोड़ी उसको कोई और मिल जाएगा. तो लॉ विल गिव मिस्टर एक्स 6 months. 6 months में तू ढूंढ ले मानसी का रिप्लेसमेंट. मिलता है तो ठीक है, तू कंटिन्यू कर. नहीं मिलता है तो भाई तू ही वॉलंटरीली LLP को वाइंड अप कर दे. नहीं करेगा, कोर्ट को पता चल जाएगा, तो कोर्ट ही डिसोल्यूशन को ऑर्डर पास करेगा. लेट्स से किसी को पता नहीं चला और ये बंदा अकेला LLP कंटिन्यू कर रहा है. 6 months के बाद whatever activities happen in LLP, that guy is gonna be personally liable. That is about your number of partners. For an LLP we discussed, and here you don't have to study what are the rules. They are just saying central government will make the rules for an LLP. That's it. LLP agreement, I told you, it is optional. If you don't have it, you can follow schedule 1. But if you have it, it should be in writing. Charters. What is a financial year? 1st April to 31st March. Here also in LLP, it is not 1st April. 1st day of April to 31st day of March. Same ही होता है. So let's say I incorporated on 1st of April 2012. Then my first year will be 31st March 2030. Okay. Let's say if I am incorporated on 2nd of June 2012, again it will be 31st March 2013. If I am incorporated on 30th September 2012, it will be again 31st March 2013. But if my incorporation is after 30th September, that is 1st October onwards, then my financial year will end next to next year. That means here it will be 31st March 2014. Q, because bacha 1st October to 31st March 2013, if you take now, it is only 6 months, which they don't want. तो 30th September तक अपना जो normal होता है वैसे. 1st October onwards, it will end next to next year. And this problem is only for the first financial year, because 2nd financial year onwards it will be proper 1st April 2014 to 31st March 2015. So this is the financial year. It's given here. Indian Partnership Act is not applicable. Now tell me, what about Companies Act? Is Companies Act applicable to LLP? Answer is no. But sometimes, you know, LLP is so big that government might think, no, it's a very big LLP, we should apply some sections of Companies Act on this LLP. You cannot do it directly, boss, wait. If government is of an opinion that some sections of Companies Act, either as it is or with modifications, with exclusions, with exceptions, should be made applicable to LLP, they will have to first propose this to both the houses of Parliament, Lok Sabha and Rajya Sabha. Once they agree with this, then only they can introduce. Otherwise, you cannot directly do it. So in your module, it's given in different places. I'm just combining everything together. So central government will notify in the official gazette if there is any provision of Companies Act is applicable or not. But before that, they have to get the notification proposed in both the houses of Parliament. 30 days के अंदर they will finalize कि भाई ये apply करना है या ये apply नहीं करना है. The next concept is incorporation of LLP. recently they had asked questions, what are the essential elements for LLP, incorporation of LLP. Which they are not asking you what are the essential elements of LLP, they are asking you what are the essential elements to incorporate LLP. And this question was asked in the past twice, same to same question. So it's already there in our book. It's already available in some other institute material. So yes, incorporation of LLP, if you ask me, there are mainly 3 steps. But if I have to tell you like proper, there are 5 steps. Just as in your incorporation of company, you had studied 7 steps. Here you have only 5. First, naam choose kar lo yaar. The name will end with LLP, but it should not be identical, it should not be very similar, it should not be offensive, etc. etc. Because बच्चा it's very well possible आप जो भी LLP का नाम रख रहे हो वो कोई पार्टनरशिप फर्म या कंपनी का नाम हो या किसी LLP का ही नाम हो, तो you have to ensure that it is not identical or it is not contravening someone's patent or copyright. So first you have to reserve the name. Once you get the name, okay, you now have to make incorporation document. जैसे वहाँ पे after getting the name you used to make memorandum and articles, यहाँ पे you will make incorporation document which is similar to memorandum. तो ये तुम बनाओ. Then you also have to get a certificate from a professional that all the rules have been complied with. That means a chartered accountant, a company secretary, advocate will give you a certificate that yes, they have followed all the rules. Imagine you being a practicing chartered accountant in future and a client comes to you asking for certificate that you please give me the certificate now that all the rules of LLP Act have been complied with. You will to tell him, अरे option में छोड़ा था, जा तू, नहीं आता है मेरे को. If a doctor tells us like this, तो जो सुनाएंगे हम उनको, we also are not exceptions बच्चा. When they pay us so much, they expect us to know everything properly na. So how can you play with your career and leave a chapter in CA? Not possible. So please mat chodo. So get incorporation document and get a certificate from a professional that all the rules have been followed. अब इस incorporation document में तुम लोग क्या क्या लिखोगे? Name of LLP, business of LLP, address of LLP, name and address of partners, etc. etc. तो पहले नाम आ गया तुम्हारे पास. Then you have to make incorporation document and you also have to put a certificate from a professional and submit all this to ROC. ROC खुश होगी और इनकॉर्पोरेशन रजिस्ट्रेशन डॉक्यूमेंट देगी 14 डेज के अंदर अंदर. मतलब आपका सर्टिफिकेट ऑफ रजिस्ट्रेशन आ जाएगा एंड उसके ऊपर ROC अपना थप्पा लगा के देगी. इट इज अ कंक्लूसिव एविडेंस दैट LLP हैज कम इनटू एग्जिस्टेंस. Then once you are registered, bacha, what is the effect of registration? LLP is a separate legal existence. Subscribers of incorporation document will become partners. They can sue, they can be sued, etc. etc. And last step, LLP agreement is optional because you know बनाते हो तो ठीक है, नहीं बनाते हो तो schedule 1 follow कर लो. And लेकिन बनाते हो तो you have to put it in writing and you have to file it with the registrar. मतलब रजिस्ट्रार को पता होना चाहिए कि तुम लोग शेड्यूल 1 फॉलो नहीं करने वाले हो, तुम लोग खुद का LLP अग्रीमेंट फॉलो करने वाले हो. सो 5 स्टेप, नाम, फिर इनकॉर्पोरेशन डॉक्यूमेंट and a certificate from a professional, submit it to ROC. ROC will give you a certificate of registration, then effect of registration, and last is LLP agreement. Now if you see the module, we have just given it little jumbled up. थोड़ा इधर दिया है, थोड़ा उधर दिया है. You can follow this. Now a lot of students will tell me, but ma'am 5 mark के लिए इतना कौन लिखेगा? 5 mark के लिए if they ask you incorporation का process, you know there are 5 steps. Write one paragraph on each in short. You don't have to write the penalty and all that in depth. Short में लिख दो यार 5 step, approximately 1 full skip side, it's fine. And वैसे भी you know that institute is quite capable of asking a 2 mark question for 7 marks and 7 marks question for 2 marks. So you need to be versatile enough to know how much to write and for how many marks. So that will come only when you do a lot of writing practice and all. Are you clear with this? Perfect. Now tell me, for LLP, every LLP, it is compulsory to have a registered office. Only if you have a registered office, ROC can communicate to you, sending you notices, you will receive notices on that address. If you change the office, you have to inform ROC so that in their details, in their particular list, they will change the details. Only this much is there. So every LLP will have a registered office. A document will be sent to this address. You can change the place, but you will have to file the notice of such change. Now here they have just amended the penalties internally. Okay, so I'm going to tell you major amendments. Major amendments में small LLP add हुआ था, then this rules was amendment, they had added this, then penalty here and there, and next very big change which they have done is here, this part. It's again important because earlier section 17 was very chill too, that later on after your LLP is incorporated, if government is of an opinion that your name is identical or it is contravening some law, something like that, then government will tell you to change it. So government will tell you to change it, change kar within 3 months, चुपचाप भीगी बिल्ली की तरह यहाँ पे change करना ही पड़ेगा. Now those who are paying full attention will have a doubt, लेकिन मैम एक बात बताओ आप, first when we had done reservation of name, वो identical नहीं था इसलिए तो approve हुआ था ना यार. अब suddenly how come they realized it later? Oh, your name is identical, oh, your name is offensive. They should have realized it earlier. I totally agree with your point, but bacha, government can make mistakes, so they are here just to cover their mistakes. I'll tell you one example. Let's say one LLP has been named as Billeri Mineral Water LLP. It is similar to what? It is similar to Bisleri, but S is missing. So it's an electronic system. तो तुम लोग अपने reservation of name के फॉर्म में बिलेरी लिखते हो तो ये अप्रूव हो जाएगा, because वो बिस्लेरी ढूंढेगा, मतलब वो मैच नहीं हो रहा है तो अप्रूव हो जाएगा. But in India we don't call mineral water, we just call it Bisleri. एक बिस्लेरी देना, वो सामने एक्वाफिना दे, किनली दे, बिलेरी दे, बालेरी दे, it doesn't matter. हमारे लिए 3 चीजें इंपॉर्टेंट है. एक, उसका सील टूटा हुआ नहीं चाहिए, दूसरा पानी दिखने में तो एटलीस्ट साफ चाहिए, एंड तीसरा सस्ता होना चाहिए. तो वो बालेरी दे, बिलेरी दे, वी डोंट केयर. तो यार बिलेरी नाम रख के बिस्लरी वालों का बिजनेस काफी ले लिया उन्होंने. बिस्लरी वाले 10 रुपए में बॉटल बेच रहे तो ये लोग 7 रुपए में बेच रहे. एंड सडनली बिस्लरी रियलाइज्ड कि अरे बाप रे, दे आर स्टीलिंग आवर नेम एंड दे आर स्टीलिंग आवर मार्केट. सो बिस्लरी कैन टेल द गवर्नमेंट, देखो ना सर वो क्या कर रहा है, मेरा नाम यूज करके वो बिजनेस कर. तो गवर्नमेंट बोलेगी नाम चेंज कर. सो बच्चा, आइदर गवर्नमेंट विल टेल यू ऑन इट्स ओन, उनको खुद को ही लगता है कि योर नेम इज नॉट प्रॉपर, या तो गवर्नमेंट विल टेल यू बिकॉज समवन हैज अप्लाइड, इन सिंपल वर्ड समवन हैज कंप्लेन टू यू दैट योर नेम इज सिमिलर टू आवर्स. तो या तो गवर्नमेंट खुद से बोलेगा या तो किसी ने एप्लीकेशन दिया है. जो भी है, वंस गवर्नमेंट टेल्स यू टू चेंज, ऑर्डर टू चेंज, यू हैव टू चेंज विद इन 3 months फ्रॉम द डेट ऑफ ऑर्डर. मतलब ऑर्डर पास हुआ लेट्स से 20th Jan 2023, तो 3 months के अंदर ये जो भी है ऑर्डर को आपको मानना ही पड़ेगा. So 3 months के अंदर. And once you change the name बच्चा, you will have to inform ROC also within 15 days, ताकि बच्चा वो लोग अपने records में नाम change कर दे. And then within 30 days, they will give you a fresh certificate of incorporation. I'm going to repeat this. Government या तो खुद से, या तो someone made an application that your name is similar. So they will order you to change. Once they order you, you have to change within 3 months. Once you change, it's your responsibility to inform ROC within 15 days. And once you inform them, they will give you a proper new certificate of registration within 30 days. But one thing is there, ये जो किसी ने complain किया आपका बिस्लेरी वालों ने, they have to complain within 3 years from the date of incorporation of your LLP. तुम्हारा LLP incorporate, बिलेरी मिनरल वाटर LLP incorporate हुए 10 साल हो गए, and then Bisleri realized, oh my god, they have stolen the name. Government will say, तू सो रहा था, were you sleeping till now? If you want to complain, you don't have forever to complain, you have to make the complaint within 3 years. चल, government order you to change the name, नाम change कर, your name is not proper. If you change the name within 3 months, okay. If you don't change the name within 3 months, Basically, you tell the government, we will not change it. Do whatever you want. Government बोलते है अच्छा बेटा रुक. Government बोलती है अगर तू सीधे सीधे you don't change your name, we will put any name we want. Chomu Mineral Water LLP also can be put. It's just an example. Of course, it's offensive. So, government will say कि if you don't follow our order, तुझे बोला था कि तू ही नाम change कर दे. अगर तू नाम change नहीं करेगा, तो हम तेरा नाम अपने हिसाब से, as per our wish, we will change it. Later on, if you don't like the name, you can change it. But again, anyways, you will have to follow the procedure given. So, simple words में सीधी उंगली से घी नहीं निकला तो उंगली टेढ़ी करके निकाल. Because they are telling you directly to change it. If you don't change it, they will change it. Eventually, you accept it or you only change it. So, this part has been included in the amendments. So, mark this part as important. So, I have explained you all these points till point number 4. I hope you are clear with this. Okay. Now, partners and their relation. Partners and their relations. So, bacha, everyone knows on incorporation, persons who are subscribing their names to incorporation document will automatically become partners. Ya to you become a partner as per LLP agreement. This we had discussed. Now, coming to cessation of partnership interest. Cessation of partnership interest. Most of the students don't know what do you mean by the word cessation. Bacha, you have heard the word ceases? Ceases? Yes. Uska noun form is cessation, that is end. Cessation of partnership interest means end. When will you no longer be a partner? When will your partnership interest end in LLP? First one, you give a notice of 30 days and you resign. होता है ना कंपनीज में 30 days का नोटिस देने के बाद आप बाय बोल के चले जाते हो, वैसा. या तो यू रिटायर एज पर द LLP agreement, जैसा LLP agreement में दिया है वैसे you can just leave. Or the partner has been now declared as unsound mind, then automatically he'll cease to be a partner. Or he has applied for insolvency or has been declared as insolvent. Or when the partner dies, again he stops to be a partner. And eventually if the firm dissolves. So if LLP is dissolved, obviously your partnership interest will come to an end. So cessation happens in 6 circumstances. You give a notice, 30 days, LLP agreement, you become unsound mind, applied for insolvency, the person dies, or the firm simply dissolves. If this happens, you have to give a notice to LLP and outsiders. Ki boss, I have left. Of course, bacha, this is not going to happen when the person dies. But other cases, unsound mind, insolvency, some representative can give that notice. So you have to officially inform LLP ki listen LLP, I am no longer a partner because of so and so reason. And you also have to inform outsider, because bacha, if you fail to inform outsider, you will continue being liable. Just as in a normal partnership firm, you had a concept, when an active partner retires, if he fails to give public notice, he will continue being liable. Same rule is applicable here. If you cease to be a partner, you have to inform outsiders, otherwise you will continue being liable. Are you clear? So this part is this, 6 points. And bacha, when you leave, you will get your capital contribution back and you will get your share of accumulated profits. So if I have left this LLP, whatever is my capital contribution, I'll get it back. Whatever is the share of accumulated profit, I will get that as well. Okay. And read this 4th point. A formal partner who is entitled to his share. Former partner means ex-partner. जिसको अभी तक उसका share नहीं मिलता है, मिलेगा आगे. That does not mean he can interfere in the management. So bacha, if a partner has died or if a partner has become insolvent, उसकी family को अभी तक पैसा नहीं मिला है, तो you can't say that family can't say तो अभी हम participate कर सकते हैं management. You can't. So that is your cessation of partnership interest. Then Registration of changes in partners, section 25. Section 25 tells you one simple thing. Sometimes bacha, partner's name changes or partner's address changes. Let's say Mansi Patil, my name changed post marriage or my address changed post marriage, whatever. So if the name or address of a partner changes, he has to inform LLP. He has to inform LLP within 15 days. And LLP will inform ROC within 30 days. So the moment my name or address has changed, I will inform LLP, and then LLP has to proceed to inform to ROC within 30 days. Now bacha, what all things LLP has to inform ROC? Following details LLP has to inform ROC. First, we spoke about this, changes of partners details. किसी का नाम एड्रेस चेंज हुआ तो वो आपको इन्फॉर्म करना है. Then changes in partners coming in or going out. If a new partner is admitted or if a partner has left, so you have to inform this to ROC. It is LLP's responsibility to inform this to ROC. And बच्चा, if it involves new partner, नहीं लिखती तो भी तुमको पता है, prior written consent of that partner also is to be submitted to ROC. This I had told you in the beginning. तो LLP को क्या क्या इन्फॉर्म करना है ROC को? पार्टनर के नाम एड्रेस में चेंजेस हुआ वो, changes in partner coming in, going out, and if it's a new partner, you have to get a prior written consent and submit that to ROC. Now, there is one point which I want to tell you. Now, bacha, I left this LLP. I had to inform LLP. Correct? LLP has to inform ROC. I informed LLP. LLP failed to inform ROC. So law says, if no information is given to ROC, this partner will continue being liable. You will be like, but man, this is so unfair. I know, so is life. But actually they say, Mansi, you know that this LLP is useless. You know that this LLP is not gonna do its job properly. If they don't do their job properly, unnecessarily, Mansi, you will be in trouble. So law says, listen Mansi, if you are so sure that these guides are useless, you go and inform ROC directly. But ROC is so over smart. If I go and inform ROC is like, oh, what if she is doing fraud? What if she is giving wrong information? ROC will say, no, I will inform LLP and just ask them, is this okay? If LLP gives the required information, matter ends. If LLP is still lazy and useless, they don't respond, then ROC will say enough is enough now. Whatever Mansi is telling us, we will assume it's true and we will register those details. Okay, I'll repeat. I feel LLP is useless. I can directly inform ROC. ROC will give a notice to LLP. LLP responds, okay, does not respond. ROC will register the change with whatever I have given. So this is your section 25. Entirely I have explained you except the penalties. This whole thing. So we finished till here. The next part is extent and limitation of liability of LLP and partner. Again, there is not a lot of amendments in this, but yes, the penalty part has been amended. So as I told you before, bacha, in LLP, there is no mutual agency. Every partner is just agent of LLP and he is not agent of other partners, correct? So see, every partner is agent of LLP but not other partners. Now what exactly is this extent of liability? See, everyone knows this, that in LLP, if you are a partner, your liability is limited to the extent of agreed contribution. That means if I have agreed to pay 5 lakhs, my liability is limited to 5 lakhs. Even if there is loss of 100 crores, I don't care, my liability is limited. So again, just as in companies, bacha, many people might take advantage of this limited liability. How? For example, let's say there is this LLP, Welcome LLP, and in this there are 4 partners, A, B, C and D. Okay, now before I tell you more about this Welcome LLP, I want you to recollect something of your Partnership Act. You had done one concept, every partner has been given some kind of authority. If he acts within authority, firm is liable. Am I right? Similarly, if he acts beyond authority, partner is liable. But tell me one thing, when I say firm is liable, indirectly I am saying all the partners are liable because there is no separate legal existence. All partners are liable. But in case of LLP, again there is some authority given to every partner. If the partner acts within authority, bacha, LLP is liable. When I say LLP is liable, not the partners, not all partners, LLP itself is liable because of separate legal existence. And beyond authority, partner is liable. Okay, so see the difference between normal partnership and LLP. Here all partners are liable, here LLP itself is liable. Keep this in mind. Now what happens is that example, Welcome LLP. There were 4 partners, A, B, C and D. Now A did fraud. Let's say A, B, C, A, B, C, D, their liability is limited to the extent of 5 lakhs. That means if things go wrong, A, B, C, D individually will give 5 lakhs. Okay. Now A did some fraud with X, which is worth rupees 20 crores. Now if something goes wrong, X is not going to sue A, X is going to sue LLP. And then when LLP asks question to A will say, I didn't do anything. You are liable because you are LLP. So if you have realized, A is taking advantage of separate legal existence, just like they had done when we had spoken about lifting of corporate veil. So here he knows that if something happens, his liability is only 5 lakhs. He is going to pay only 5 lakhs in spite of the actual fraud amount being 20 crores. So law says, wait, if you are smart, you are over smart. If you do any fraud, if you do any activity which is fraudulent, your liability will be unlimited and it can be extended even to your personal assets. So this is very much similar to lifting of corporate veil, but I cannot use the term lifting of corporate veil because these words are reserved only for companies. You just have to say that if any fraud is committed by a partner, his liability is unlimited and it can be extended even to their personal assets. One more thing, if fraud is done by A, B, C, D are not liable just because they are partners of LLP. Welcome LLP is liable and in turn Welcome LLP will recover the amount from A and A's liability will be unlimited. So there is a protection available to B, C and D. That is your liability here. So see, LLP is liable if a partner does something in normal course of business. But if a partner acts beyond authority, LLP is not bound. Obligation of LLP is solely obligation of LLP. Liabilities of LLP will be met out of property of LLP only. You cannot go to the partners. But if there is fraud, yes. Now see, these 2 points, a partner is not personally liable solely by the reason that he is a partner. I told you, A kuch karta hai, that does not mean B, C, D are liable just because they are partners. Partners are personally liable for their own wrongful acts. But partner is not personally liable for any other partner's wrongful acts. We discussed this. Then, you had a concept of holding out. I am going to make it comparable with a normal partnership firm. Let's say this is a normal partnership firm and ABX are partners, sitting together, not related to each other. B tells X, you know what, I am partner of Mr. A. A keeps quiet. So X assumed that both of them are partners. And X ended up giving a loan of 10 lakhs to A and B. Who is liable to X? A and B both are liable by the principle of estoppel or holding out. Correct? Now, if I talk about LLP here, A, B, X are sitting together. A is already a partner of Welcome LLP. B and X are not related to him. Still, B tells X, you know what? I am A's partner in Welcome LLP. A again keeps quiet. He's neither deaf nor dumb, still he keeps quiet. So, X obviously will assume that they both are partners of Welcome LLP. Thinking that they both are partners of Welcome LLP, X gives a loan of 10 lakhs to Welcome LLP and Welcome LLP accepts it. So here bacha, Welcome LLP is liable. Later on they can't say ki, we don't know who on earth is B. But why did you accept the benefit? You did accept the loan, so you are liable to pay for it. So here partners are liable, here LLP is liable. That is your holding out. And as I told you, in case of fraud, your liability is unlimited. Not only this, bacha, your liability in case of fraud, your liability is unlimited. Then you will have to pay penalty if you are a party to that fraud, if you are involved in that fraud. There also will be some criminal proceedings which will be started against you. You will also have to pay compensation, pay damages to the aggrieved party. So basically, if you do fraud saying that I didn't do, LLP has done it, again they will catch you. So there is no lifting of corporate veil, but there is unlimited liability. This is what is this part. Penalty and all. Now, whistleblowing. Now, if I ask you what is whistleblowing, you will tell me very shamelessly, CT marna. I'm not asking you only. So, whistleblowing means blowing up the matter and making it come to the notice of the people. In simple words, if I have to put it in simple English language, chugli karna, bhanda fodna, you can put it. So, for example, I was an employee of LLP and I came to know these partners are up to something wrong. So, I informed someone, I complained. So, it is me because of whose complaint the entire matter came into focus. So, I am known as a whistleblower. Now, because I gave so much important information, it's very well possible those partners, LLP, will get convicted. And so, in order to take revenge, they might kick me out from my job, they might just suspend me, demote me, reduce my salary, harass me, etc. etc. Section 31 says, wait, we are here coming to your rescue, Miss Mansi, that if you give some important information, no partner or employee can be discharged, demoted, suspended or harassed in any manner just because he gave the information. So, this section protects me. Clear with this? Perfect. Now, coming to your financial disclosures, which is a very short part, it looks big, but it's very small. So, there are three things which you have to take care of in LLP. First, bacha, you have to make proper books of accounts. Obviously, you will make this on double entry system of accounting. Get it audited by a proper CA if it's required. You have to follow accounting standards and standards of auditing. Just as there are accounting standards, there are standards of auditing. Just as you need some proper standards for you to start your accounts, here you need to follow some proper standards to start the auditing also. And who makes this? It's ICAI. So ICAI recommends this to central government and central government announces it to the public. But now, between us, ICAI and central government, there is someone coming here and that someone is NAFRA, National Financial Reporting Authority of India, which is formed under Companies Act. NAFRA says, wait ICAI, you have to tell this to us, we will inform central government and they will announce. So basically they don't believe us completely, they say that There is a National Financial Reporting Authority of India. You first get it confirmed by them. First you have to show it to them. You have to make the changes whatever they prescribe, and then this will be again forwarded to CG. So make proper books of accounts, follow the standards. Second bacha, you have to file statement of accounts and solvency, and you have to file this within 6 months from the end of the financial year. So every year, whenever your financial year is over, you have 6 months to make the statement of accounts and solvency. Submit it to ROC within 6 months, and of course it will be signed by 2 designated partners. Then you also have to submit annual returns. Every year ROC wants to know what you did in that year. So you have to submit annual returns within 60 days from the end of the financial year. Again, it should be signed by designated partners. Remember 6 months and 60 days. So books of accounts, then you have statement of accounts and solvency and annual returns. So this is your entirely financial disclosures. This part they have added new. So this is amended. Now, conversion into LLP. Now, bacha, I had told you this before. Let's see how much do you recollect. That a normal partnership firm can be converted to LLP. A private company can also get converted into LLP. Unlisted public company can also get itself converted to LLP. Can you recollect and tell me the respective schedules? This is schedule 2 because schedule 1 was your instead of LLP agreement. This is 3, this is 4. Just think and tell me, if earlier you were a partnership firm, you used to go to registrar of firms. Now you will go to ROC. Here ROC, again ROC, but the department will change. Again ROC, here also ROC, department will change. So how will you do the conversion? First of all, register LLP. एक बार तुम लोग ने LLP खोल दिया, you have to inform old ROF and ROC, जो भी है, whatever is the case. If it's a firm, then ROF, and if it's a company, then ROC. You have to inform old ROC and ROF कि we are boss now going. Please remove our details from your records. So you inform them within 15 days, they will do the needful. Some students might say, but ma'am ROC के पास ही हो और आप वापस ROC के पास जा रहे हो, तो what is the need for you to inform again? But बेटा department तो change होता है ना, so you have to officially give them that intimation. चलो ये हो गया तुम्हारा. उसके बाद the old partners of firm or the old members of company will automatically become new partners of LLP. नहीं लिखती तो भी तुमको पता है. Fourth one, all the assets, liabilities, interest, etc. of old firm or company will become assets and liability of new LLP. And lastly, bacha, the old firm or the company is deemed to be dissolved. It's gone. So they cannot coexist because you have converted it. So these are the 5 points given about conversion. See, you can convert as per second, third, fourth schedule. How will you do it? What is the effect? We discussed all of this. Okay, so fairly manageable this part. Coming to winding up. In your Partnership Act, you had done dissolution of the firm with court's intervention, without court's intervention. Correct? That means one, court is not telling you to dissolve, but you are dissolving on your own. Or second, court is telling you to dissolve because of certain reasons. Here also, either you can voluntarily wind up if you feel like, or it will be as per the order of tribunal. Court आपको बोलेगा कि चुपचाप dissolve कर दे. कब बोलेगा? When you only make an application to the court and tell the court, sir, I want to dissolve, but these other partners are not listening. Can you please give an order for dissolution? Second one, more than 6 months have passed by and still you are continuing with one single partner, so they will tell you to dissolve. Third one, you are unable to pay your debts, so please don't continue, dissolve. Fourth one, for 5 years consecutively bacha, you could not submit the statements of accounts and insolvency and annual return. भाई तुमसे नॉर्मल डॉक्यूमेंट 5 साल लगातार सबमिट करने को होता नहीं है. हाउ आर यू गोना मैनेज LLP? बंद कर दे भाई, छोड़ दे. So 5 years consecutively you could not submit this document, they will tell you. Or you did something against the country, against India, or any other reason which they feel is fine. So once they had asked this for 5 marks, so partner has applied, more than 6 months has passed, no debts have been paid, you are unable to pay your debts continuously, more than 5 years consecutively you are continuing with the default of statement of accounts, insolvency and annual return, you are doing something against the country or any other reason. And what are the rules of winding up? Central government will tell you the same. See, this is your rule and the rules will be given by central government. You can mark this as important. Miscellaneous is quite simple. Bacha, can a normal partner enter into any transaction with LLP? Yes, because LLP is different and the partner is different. And when LLP Act was made, it was 2008. So at that time, electronic system was started. So they can file all the documents electronically. This is amendment. They have inserted it. Now, if you see the last part of your RTP amendments, you will find a lot of things and you will be like, what is all this? It's actually very, very simple. Now, I'll tell you one thing. You saw that LLP Act also will be governed by ROC and Companies Act also will be governed by ROC. So, it is very well possible that it will become too crowded. They will have to manage a lot of things. So, they are just telling you that they will set up registration offices wherever required. See, if I set up only 2 Aadhaar offices, so obviously it will be very inconvenient for everyone. If I set up more and more offices, it will be very convenient for everyone. Yes, so here also they are telling you the same thing. So for the purpose of exercising such powers and discharging the functions, government बोलता है कि we will establish such number of registration offices which we think is fit. We will specify the jurisdiction. Ki you office, you will take care of this area, you office, you will take care of this area. Second point, इस ऑफिस में सेंट्रल गवर्नमेंट रजिस्ट्रार्स, एडिशनल रजिस्ट्रार, जॉइंट रजिस्ट्रार्स, डेप्यूटी रजिस्ट्रार, जैसे पुलिस में होता है ना डेप्यूटी कमिश्नर, जॉइंट कमिश्नर एक्सेट्रा, वैसे यहाँ पे भी करेंगे. सो टू कीप इट सिंपल. एंड इनका जो पावर्स एंड ड्यूटीज है वो गवर्नमेंट बोलती है हम बोलेंगे, इट विल बी प्रिस्क्राइब्ड. ओके. And central government will give an order to this registration offices ki you can also have your common seal which you can put on any document of LLP. So they are going to direct ROC to prepare seal or seals for authentication of documents. इतना ही बोला कि हम सिर्फ registration office ऐसा setup करेंगे और उसमें कौन होगा कौन नहीं होगा वो बोलेंगे, कब पता नहीं लेकिन बोलेंगे. Next, what was the time limit for you to submit your insolvency and a statement of accounts and insolvency? 6 months. An annual return 60 days. अगर थोड़ा लेट होता है तो चलेगा, तो you just have to pay the additional fees. What is the additional fee that they have not given you? They are just saying for different fee, for different class of LLPs it will be given. That's it. And this establishment of special court is again newly inserted, so it is entirely amended. First, जैसे बच्चा you in companies have NCLT, you know, special court. So government says कि हम LLP में भी special court set up करेंगे. So central government for purpose of providing speedy trial of offences, what a joke, will establish special courts कि फटाफट केस सॉल्व हो जाए उसके लिए, yes फटाफट मैटर खत्म हो जाए उसके लिए हम स्पेशल कोर्ट्स जो है वो अपॉइंट करेंगे, बनाएंगे. और स्पेशल कोर्ट में कौन रहेगा? सिंगल जज and a metropolitan magistrate or a judicial magistrate of first class. Ma'am, ये लोग कौन है? It's just the judge. That's it. It's a terminology given. So special court में single judge होगा and metropolitan magistrate or judicial magistrate of the first class. लेकिन बच्चा they are telling you section 67A में कि हम special court बनाएंगे. जब तक ये special court बनेगा तब तक यू फॉलो द स्पेशल कोड गिवन इन कंपनीज एक्ट। तो जो भी कंपनीज एक्ट में स्पेशल कोड है उसमें तुम अपने एलएलपी के प्रॉब्लम्स लेके जाओ। बट सैडली बच्चा कंपनीज एक्ट में भी ऐसा दिया है कि हम स्पेशल कोड बनाएंगे, तो जब तक वहां पे स्पेशल कोड बनते हैं यू हैव टू गो टू सेशंस कोर्ट और मेट्रोपॉलिटन मजिस्ट्रेट और जुडिशियल मजिस्ट्रेट ऑफ द फर्स्ट क्लास। कोई बोलेगा मैम ये पहले से क्यों नहीं दिया? आई एम गोइंग टू रिपीट दिस, दोज हु आर स्टिल सीइंग स्टार्स पे अटेंशन। सबसे पहले फटाफट केस खत्म करने के लिए वी विल सेट अप स्पेशल कोर्ट्स। उसमें कौन होगा? सिंगल जज या मेट्रोपॉलिटन मजिस्ट्रेट और जुडिशियल मजिस्ट्रेट ऑफ द फर्स्ट क्लास। जब तक हम ये बोलेंगे तब तक यू गो टू कंपनीज एक्ट का स्पेशल कोर्ट। जब तक वहां हम स्पेशल कोर्ट बोलेंगे तब तक यू गो टू सेशंस कोर्ट और मेट्रोपॉलिटन मजिस्ट्रेट और जुडिशियल मजिस्ट्रेट। कोई बोलेगा मैम सीधा लिख देते, नहीं बच्चा, अगर कंपनीज एक्ट का पहले स्पेशल कोर्ट बन गया तो आप कंपनीज एक्ट वाले स्पेशल कोर्ट में जाओगे, अगर यहाँ वाला पहले बन गया तो यहाँ वाले में जाओगे। These are your 4 points. Just that the language is little difficult. Are you clear with this? Perfect. Now procedure and powers of special court. And I am just telling you for your knowledge. You know, simple words में मैं ज़्यादा इसको elaborate करके नहीं समझा रही हूँ. There is something known as court trial. मतलब सुनवाई. You know, you might hear a term, court is trying a case. मतलब court is listening to your case. Court trial चल रहा है मतलब उस court में the case is going on, sunwai is going on. So there is something known as summary trial and there is something known as summons or warrants trial. Now you will feel, ma'am, what is the difference? Summary trial in simple words में if I have to tell you, it's shortcut, फटाफट आ जाता है, and summons trial is a very long process. तो मैम हम तो shortcut में ही जाएंगे ना? नहीं, you can take only those offenses जहाँ पे imprisonment given is maximum 3 years. तो अगर कोई सेक्शन का ऑफेंस है जहाँ पे imprisonment is given as 5 years, तो ये बड़ा ऑफेंस है बच्चा, तुम शॉर्टकट में नहीं लेके जा सकते. You can go for summary trial only for those offenses where imprisonment given maximum is 3 years. लेकिन वहाँ पे जो जज बैठा है, he has some restrictions. He can announce punishment of only up to 1 year. So ma'am, what is the difference between 3 years and 1 year? So if you observe na bacha log, everywhere in law they will write up to, minimum, maximum. So they will not give you exact number. They will always give you a range. तो अगर तुमको शॉर्टकट में जाना है तो सिर्फ वही ऑफेंसेस लेके जाओ जहाँ पे एक्ट में मैक्सिमम 3 साल की सजा दी हुई है. लेकिन when you go, वो जो जज बैठा है, he can announce punishment only up to 1 year. That's it. कम लगता है तो तुम समन्स में चले जाओ. Let's say I took a case to summary trial. I'm okay with the 1 year imprisonment punishment also. But वहाँ पे जो जज बैठा है उसको लगता है no, this offense is very big. So we should put it for summons trial and not summary trial. So they will record it on that case paper and they will forward it to summons trial. So बच्चा summary trial में जाना है, summons trial में जाना है, it will be decided by us as well as the court. If court thinks कि ये punishment बहुत कम है, then they will only forward it for summons trial. That is your summary trial and all, high court and all. And I have given you the meaning of all of this here. After the summary, see here. Tried by the court, what is summary trial, etc. Distinguish between, so I am sure you will manage. So this was your amendments, additions and everything. I am sure that the entire LLP Act is very simple for you. Okay, quickly revise it. Definitely 5 marks के लिए very simple and chintu question they are gonna ask you. Okay, all the very best. My good wishes to you. Bye bye. Take care.